Assalamu alaikum and welcome back to Just Law on IQRA TV. I'm your host Ilyas Bulbulia. This is the second part to the show. Just before the break, we were looking at the position of those people who have overstayed in the United Kingdom and who want to regularize their stay in the United Kingdom based on children that they may have. We'll look at that in greater detail, but as always, Just Law is a live show. So whatever questions you have, you can give us a ring on the number that appears at the bottom of your screen. And inshallah, we will be able to deal with any queries that you have, whether it's related to immigration matters or non-immigration matters. The number that you can call on appears at the bottom of your screen. Now, the position of those who have overstayed in the United Kingdom who want to make an application based on children. We looked at sort of typical scenarios that you come across on a daily basis. Those people who've overstayed, they want to make an application based on their child that is British because they are in a relationship with a partner who is British, and the child from that relationship would obviously then be British as well. So a situation where the application is made on the basis of a child that's British, or it may well be that the child is not from their relationship, it may be from the partner's former relationship. And the third kind of situation that you come across when dealing with applications based on children is where the child is not British but has lived in the United Kingdom for a period of 7 years. The child might have been born in the UK or not born in the UK but has lived in the UK for 7 years. So you've got a number of different scenarios there. And what I was saying in the first part of the show is that whatever the scenario, the Home Office has its own requirements that need to be fulfilled in relation to each of those categories, and the Home Office deal with each of these different categories in practice in a different way. So if you look at the first category, where from the relationship there is a child that is British, and in my experience that's one of the more easier applications that can be made. Generally speaking, the level of inquiry or investigation as far as the Home Office is concerned is much less than the other two categories. There are obviously requirements that need to be fulfilled. Generally speaking, what the Home Office position is that if the parties are married, legally married, and there is a child from that relationship, and the child lives with the family, the person who's overstayed and their partner and the child, they all live together in a family unit. If that is the case, then the Home Office's position is that the requirements for a visa under what they call Appendix FM, the 10-year partner route, is met at that stage. And the Home Office will grant a visa as long as you can demonstrate that yes, your partner is British, the child is British, you are the father or mother of the child, and you're all living together. Generally, the Home Office will then grant a visa based on that. Now, there is another situation which you come across where the child is British, but the parents aren't legally married. It may well be that they've just had an Islamic nikah and they're living together, but they've not formally married. Now, even in that situation, the Home Office position is that although the immigration rules, the rules contained in what is called Appendix FM, the 10-year partner route, even though the rules aren't met because the parties aren't married, and it may well be that the parties can't demonstrate that they've been living together for 2 years, even though the requirements aren't met in the immigration rules, as long as the Home Office can be satisfied that the person who is applying, the father or mother, is actually looking after the child, the Home Office will still grant a visa to the parent who has overstayed. So generally speaking, where there is a British child and the parties are living together in a family unit, they're the more simpler type of cases. The Home Office generally, with limited evidence, if we say that, accept the position and grant some kind of leave to remain. The sort of key documents that the Home Office tend to ask for where it's the case that the child is British, and we're able to demonstrate that by way of birth certificates and passports, is that the parent who is the overstayer is actually living with the child, is actively involved in the child's life. And that is normally demonstrated by showing that the parties all live together, so documents coming to the same address for the mother, father and the child. And maybe what the Home Office will ask for is a letter from the school or the doctor confirming that the parent who's applying is taking some kind of role in the child's life. So if it's a letter from a school, it may well be that the school says yes, the parent comes and drops the child off, picks the child up, or comes to parents' evenings, etc. If it's a letter from the doctor might say yes, as far as we're aware, all the parties live at the same address, and yes, mum or dad, whoever's the overstayer, does come to the surgery with the child. If you're able to sort of submit that level of evidence, then the Home Office will normally grant a visa. And the visa that's granted is for 2.5 years. Every 2.5 years, that visa needs to be extended. And ultimately, after 10 years, the parent who's the overstayer, who's now managed to get a visa under this route, qualifies for indefinite leave. There's no financial requirement, there's no English language requirement, there's no requirement as far as accommodation is concerned. It's an application which is simply based on the parent who's overstayed having parental responsibility for a child who's British. Now, that's the more straightforward kind of application. You might come across a situation where the child is British and it is the child of the parent who's overstayed, but the relationship with the partner has broken down. And it may well be that the relationship has broken down and the person who's applying is living elsewhere, not within the family unit, and does have contact with the child. The contact may well be once a week, might be twice a week, whatever it is, but there is contact. So even in that situation, even though they're not all living together, and there's no evidence obviously that they are living together, even in that situation, as long as there is evidence that the parent who has overstayed is actively involved in the child's life, in the sense that there is frequent contact, then an application can be made based on there being a British child even in that situation. The problem is that the evidence that the Home Office requires where the parties have separated, where the mother and father of the child do not live together, and the child doesn't live with the parent who's overstayed, child lives with the partner who is legal in the United Kingdom. The only difficulty is the kind of evidence that needs to be submitted. You have to demonstrate, the person who's overstayed has to demonstrate that they are in regular contact with the child. Now, that evidence is either confirmation from the parent with whom the overstaying parent has split, or a court order. Now, that sometimes causes a problem, but in my experience, it's not a problem which is insurmountable. It is something that can be sorted out. If you can persuade, the person who's overstayed can persuade the other parent to give a statement confirming that the other parent is having regular contact, fantastic. If not, it may well be that if there are problems with contact, what the parent who's overstayed may well have to do is see a family lawyer and get contact going, get an order from the court basically ordering that contact should be taking place. That as an alternative piece of evidence of contact with the child would also be sufficient. So here the key thing is, if you're not together as a family unit, that's not necessarily fatal for the parent who's overstayed, as long as you can demonstrate you have contact with the child who's British. That in itself would be sufficient. The only problem is in terms of the evidence that you need to collate to demonstrate that. So that's a situation where the person who's overstayed is the biological parent of the British child. The second scenario is where the parties are living together as a family unit, but the children there, it's not the child of the person who's overstayed. It may well be that the child is the child of from a partner's former relationship. Now, that is a slightly trickier application because the Home Office will normally look at this in greater detail and will want to know what involvement this parent who's overstayed is having with their stepchild. So normally, in my experience, there's a greater degree of scrutiny for these kind of applications. So it may well be that we'd have to demonstrate what, on a day-to-day basis, this parent is doing for the child. You will probably need to submit like a statement or a detailed explanation from the other parent, the actual biological parent, saying, look, my partner, although not the biological parent of the child, is taking an active role. And again, what we discussed before, in terms of getting evidence from the school, from the doctor's surgery, etc., the Home Office will place more emphasis on that. So the Home Office will generally only grant a visa in that situation where they are satisfied that the parent who has overstayed is really actively involved in the stepchild's life. Now, in my experience, the younger the child, the easier it is to demonstrate. So, for example, if you've got a child who's 5, 6, 7 years old, it would normally follow that the stepfather who's overstayed would normally be taking the child to school, etc. So there'll be more evidence and more involvement in the child's life. However, where the child is much older, let's say maybe 14, 15, 16, the involvement is normally much less. So it's sometimes more difficult to demonstrate that. But having said that, even though the child is a stepchild, it is still possible to make an application based on the stepchild for leave to remain in the United Kingdom, albeit it's a more complicated application that needs to be made and will attract more scrutiny. So you need to be careful about that. The sort of last category I want to look at is, in my experience, the most sort of difficult application that one can make as far as children is concerned, which is where the children are not British, but the children have lived in the United Kingdom for a period of 7 years. And that's a situation where potentially what the argument is that's been put to the Home Office is that, look, these children have lived in the UK for 7 years and these children have now established and laid down roots in the United Kingdom and therefore should not be required to leave the UK. If the children shouldn't be required to leave the UK, then the parents or the parent who's overstayed should also not be required to leave the UK. So it's a slightly more difficult application to make because, unlike the other applications where, because of the status of the children, it's taken as read that they've got the right to stay here, and you don't really look at whether they can move abroad. Here, where the child is not British, the Home Office will look at whether the child can be required to leave the United Kingdom or not. The test is whether it is reasonable to ask the child to leave the United Kingdom. So the difficulty with those applications is that one has to demonstrate, first of all, the child's particular circumstances. So in terms of how they have laid down their roots in the United Kingdom. So the amount of time they've spent in the UK, in terms of the education system that they've been involved in, if they had to leave the UK, how that would be affected, how that would be disrupted, how they might have extended family in the United Kingdom, who they have a close bond to. It may well be that there are grandparents who are here, or uncle, aunts, etc., who are here, with whom they have a close bond. It may be that they have established themselves in terms of all their family, etc., are here in the United Kingdom, and their links to their home country might have been broken. They may not speak the language spoken in the parents' home country. It may well be that they have no family in that home country. They've never visited that country either. So these are all factors that will need to be addressed in order to demonstrate that it is not reasonable to expect the child to leave the UK. We'll take our next call and we'll return to this topic later. Hello, Assalamu alaikum.
Alaikum, brother.
Brother, thank you for calling. What's your question?
Brother, just inquiring, on how to get visa for my wife.
Okay.
I've got my child come over for a visit,
Okay.
but it's sent them back. We've gone back now, and I dropped her off.
Okay.
But I wanted she's been refused twice now.
Okay. All right. Okay. And do you know on what grounds the application was refused before?
There's something to do with the English.
All right. Okay. All right. Okay. That's fine. Now, I think look, what the where there has been previous refusals, the starting point always is to look at why the application has been refused. So if you do, whoever you go to for advice, you do need to look at what why the first application was refused, why the second application was refused. And really the starting point is we need to address why it was refused and what can be done on this occasion to ensure that the same grounds for refusal do not come up again. Now, if you're saying that one of the reasons for refusal was the English language requirement, you need to look. Now, is it possible for her to pass the English test, or is she going to find it difficult to pass the English test?
She's finding it difficult.
Okay, all right. Now, there are some exceptions for people who are unable to pass the English test, but unfortunately, they're quite limited. If, and I don't know what the case is here, but for example, if somebody has a mental illness and that is the reason why they are unable to pass the English test, whether it's depression or whether it's dementia or whatever it is, and I don't know what the situation is, your wife, and I don't want to ask you live on air. But if there are particular reasons, medical reasons, as to why your wife cannot pass the English test, then it may be possible to use the exemption that's there for people who are unable to pass a test for medical reasons. So one option is, your wife keeps on trying to pass the test. The other way is that if there are medical reasons, then you look at obtaining medical evidence from the doctor back in the home country, who hopefully would be able to confirm why it is from a medical reason she is unable to pass the test. So that's one way of dealing with it. Unfortunately, if you cannot gain an exemption under medical grounds, it is very difficult to get a visa, because the English language requirements apply to everybody from the age of 18 to 65. So it's very difficult to get some kind of exemption from that, I'm afraid. So really, if the difficulty is English, I think the only way out I can see is that if there are medical reasons which are the real reasons for her not being able to pass the test, then use that as an exemption. Apart from that, she's going to have to carry on, unfortunately, doing whatever course that she can go on to get her English up to speed.
Yes, Jazakallah for that, brother.
No problem at all. Thank you very much for your call. Thank you. Walaikum salam. Thank you. Unfortunately, the English test does pose a problem for a lot of people. There are no ways round it in reality. In my experience, what tends to happen is, even if somebody is finding it difficult, they normally enroll on a course which may take 1 month, 2 months, 3 months, and basically persevere. And if one does persevere, in my experience, ultimately after 3-4 months of studying, most people do manage to pass the test. So unless an exemption applies, like a medical exemption, the only option is to carry on and hope that with all the effort that one puts in with attending a course, ultimately that leads to a successful result when it comes to taking the test. So just before the call, we were looking at the position of overstayers and how one can obtain some kind of rights in the UK. One is an overstayer based on children. The final category I was looking at was the category of somebody who has children who aren't British citizens but who have lived in the UK for 7 years. And what I was demonstrating is that the test that the Home Office will apply in that situation is to look at whether it is reasonable to ask the child to leave the UK. And when assessing reasonableness, the Home Office will look at a whole range of factors as to how, in terms of the child, how they have established roots in the United Kingdom. So they will look at a whole host of factors. If it is possible to demonstrate that it would be unreasonable to ask the child to leave the United Kingdom, then what happens is that not only is the child granted a visa to live in the United Kingdom, the parents or the parent who has overstayed in the United Kingdom, off the back of that, is also granted some kind of leave to remain in the United Kingdom as well. So the child gets a visa and the parent or the parents get a visa as well. But that category is different to the position where you have an overstayer who has British children or whose partner has children who are British from a former relationship. It is much easier, in my experience, to qualify under that category if we're relying on the residence of the children for 7 years. It is a slightly more difficult application because it's not assumed by the Home Office that it is unreasonable to send the children back. That has to be proven. Now, one good thing there is this, that if the Home Office, after you make an application, if the Home Office refuses the application, then normally you will be eligible for a right of appeal, which is an in-country right of appeal. So you won't be asked to leave the UK and to pursue an appeal. You will be able to pursue an appeal in the United Kingdom. Now, the big advantage with that essentially is that you get a second bite of the cherry. It may well be that the Home Office isn't convinced that a visa should be granted to the child who's overstayed a visa, and that a visa should be granted to the parent. The Home Office may not be convinced of that, but you do get the chance to try and convince a judge when you attend your immigration appeal. You do have the opportunity to try and convince a judge that some kind of visa is should be granted based on the child's residence in the United Kingdom, based on the child's life in the United Kingdom, based on the fact that the child has limited or no contact with family, etc., or no links with the home country. So there is a chance, and there is a very good chance, that with good evidence, good representation and a sympathetic judge, you could ultimately get some kind of leave from the appeal that you pursue. In all these cases, if your application is successful, you would normally be granted a visa or leave to remain for a period of 2.5 years. And that's the norm for all of these cases. Visas are granted for 2.5 years. After 2.5 years, one has to make an application to extend one's visa again. So in 2.5 years' time, you have to keep your eye on the fact that in 2.5 years' time, another application will have to be made. And when you get to that stage, unfortunately, you have to go through a similar process again in terms of demonstrating, if you're living as a family unit, that look, we are living together, this is how I'm involved with the light. If you've with the child's life, if you've separated, again, confirmation of contact with the child. And if your child has been living in the UK for 7 years and you manage to obtain some kind of visa based on that, then again, you have to demonstrate that, look, you are living within the family unit, and the child on whose basis you managed to obtain some kind of leave to remain is also living with you as well. So there are a number of things that you need to demonstrate again when you apply for an extension of your visa in 2.5 years' time. The problem with this visa, as I see it, is this, that it's fantastic. You manage to get a visa, you manage to stay within the system, which is fantastic. The problem that I see is that it does take a considerable period of time to obtain indefinite leave under this system, because this is a visa where settlement is obtained after spending 10 years within the particular category under which you've been granted a visa. So it's a 10-year route to settlement, whether it's classed as a 10-year partner route, whether parent route, partner route when you're living together, 10-year parent route where you're separated but you have contact, whatever the route is, it does take a considerable amount of time to obtain indefinite leave. Fortunately, that brings us to the end of the show. Inshallah, we'll be back next week on Monday at 6 o'clock. Until then, Assalamu alaikum.